Okay, good evening, everybody. It's 8:30 here on the East Coast, and I want to welcome you to another National Fellow Online Lecture Series. This is sponsored by the AMSSM Fellow Online Education Subcommittee, in addition with the AMSSM Education Committees and the Fellowship Committee. I want to remind everybody to tune in next week, the same time. We're going to go having an lecture on X-rays of the shoulder, clavicle, and elbow, presented by Dr. Robert Boutain, and then moderated by Dana Shang. And then tonight, we're going to talk about the medical legal aspects of sports medicine with past AMSSM President Chad Asplund. Before we get started, we'd also like to mention the goals of the National Fellow Online Lecture Series, which are to serve as an adjunct to your individual program's educational content, provide fellows with direct access to educational experiences with AMSSM members, and at times invited guest experts. And this is to assist in the CAQ exam preparation. And some reminders to please mute your devices, microphones, and turn off your video. Please submit any questions that you might have throughout the lecture through the chat function, and I will go ahead and present that to Dr. Asplund at the end of the lecture. Please complete the evaluation at the end of the lecture as well. And then lastly, in an effort to elicit more input from our audience, please fill out our fellow online lecture series form to provide topics that you feel may be relevant in the future. A web link can be found by going to amsssm.org, click on the Education tab, and then select the fellow online lecture series. And then second is by scanning this QR code. It should take you directly to the form to fill out. When filling out the form, we ask that you please keep in mind that the primary goal of this series is to assist in the CAQ preparation for fellows. So to get to our lecture tonight, it's my pleasure to welcome Dr. Chad Asplund. Like I said, he is a prior AMSSM past president. He is currently the head team physician at Georgetown University and has over 20 years of experience in sports medicine. He has served as a medical director for USA Basketball and is a team physician for USA Hockey and USA Triathlon. Dr. Asplund is the past president, like I said, of American Medical Society for Sports Medicine and the executive director of U.S. Council for Athletes' Health for Mayo Clinic. He's a leader in practice and policy, and it's a privilege to have him here speaking to us tonight. And with that, Dr. Asplund, I will turn the screen over to you.
All right, thanks, Myro, and thanks to the Fellowship Committee. Let me go ahead and share my screen, or here we go. Let me get my screen up, and we'll go ahead and get started. As you said, I'm going to talk about medical legal issues in sports medicine. Having contributed some questions to the most recent CAQ, there are several questions on this topic, and so there are some key points that will get hit for your CAQ. So nothing really to disclose. As Anthony Butler likes to say, you know, I'm not receiving any money from anybody, but if someone wants to give me money, I'll take it. But no real financial relationships with commercial entities. These are the topics that we'll cover tonight. The legal issues, we'll talk about what are the legal issues surrounding the team physician, what is standard of care and how does that apply? Is there a legal requirement for a pre-participation exam, and if so, what should that entail? Clearance to play or disqualification decisions, you know, who have the courts sided with in the past, who has sort of the last say on clearance to play. There's always a lot of confusion about the Good Samaritan Act, and a lot of people think they're covered under the Good Samaritan, but they may not be, and we'll talk a little bit about that. We'll talk a little bit about waivers, and you know, athletes often want to say, well, I don't care about all of this. I'll sign a waiver. You know, do those hold up, and are they legit? The last thing we'll talk about is kind of some of the new stuff that's coming with the NCAA and how that may impact sports medicine care in the future. So when we think about the team physician, many of us in AMSSM, many of you fellows did a sports medicine fellowship hoping to become a team physician. And, that's really kind of the fun stuff of what we do. And so some of the legal precedent is, if you go back to King in 1981, the team physician must provide medical treatment and advice consistent with the athlete's best interest because there is a physician-patient relationship. Have a legal duty to conform to the standard of care corresponding to their actual specialty training, and be aware that there may be a conflict between ownership or the school, the athlete, and the physician, but to always remember that as the team physician, you represent the best interest of the athlete or the patient. The standard of care, when you think about malpractice and when you think about cases, you're always kind of held to what is the standard of care. A case back in 1988 said that team physicians must have and use the knowledge, skill, and care ordinarily possessed and employed by members of the profession in good standing. So is the care that you provided reasonable? Is it current? Is it the standard of care? Malpractice is generally based on harm caused by negligence in light of the general knowledge and skill of the medical profession, and team physicians have a legal duty to conform to that standard of care. When we think about the accepted practice standard, or that practice of care, what should have been done? A lot of times when things go to court, they will bring in experts who, Monday morning quarterback your decisions, but it's really, they're coming in looking at what are the accepted standards, what are the current guidelines, did the care that was provided, did they meet current guidelines or current standards of care? The accepted practice standard is different, but it may have several advantages in the sports medicine context because it focuses on the current state of medical art rather than a historical conduct. When I think about that, I think, what are we doing right now with orthobiologics? What are we doing with some of our injectable therapies? That is evolving, and there is no real defined standard of care, but certainly if they brought in experts to talk about how you might use PRP or stem cells in a high-level athlete, certainly being up to date on the current literature and what is the accepted practice would be very helpful. And really, this accepted practice standard allows physicians to adopt innovative treatments for athletes as long as they're adhering to what is kind of the current state of knowledge or practice. So liability issues, when you think about the accepted practice standard, Garner v. Holyfield is one of the first cases. Basketball player passed away. The mother alleged that the cardiologist misinterpreted ECGs and missed a diagnosis of Marfan's. The experts said that proper consultation and follow-up care that wasn't provided would have prevented death and given a normal life expectancy. And so unfortunately, for the physician, the patient won in that case, in that settlement. So the real key things here are, consultation is going to be key, and we'll see that in the next few slides, that, as a primary care sports medicine physician, if something is outside the realm of your scope, like a cardiology issue or a neurology issue, making sure that, you're engaging your subspecialty colleagues will certainly protect you. So PPEs, pre-participation screening, having been a sports medicine physician for a long time, you end up doing a ton of PPEs, and some days in the middle of, PPE number 123, you're wondering, why are we doing these? Should we even do them? Well, I mean, the law requires that a medical examination of an athlete to determine fitness to play be conducted, but be reasonable under the circumstances. And what that kind of looks at, or what that differentiates, is, the level of competitive play is sort of a relevant factor in defining what is the standard for a PPE. obviously for those who have had experience taking care of professional athletes, that PPE is a lot more in-depth and advanced than what a high school athlete may get. And that's not always correct or the right thing, but resources, the amount of investment in the athlete, the risk versus the benefits are all something to be kind of factored in. As we mentioned, professional and college players generally receive a more comprehensive medical exam because of the extreme demands and the level of play, coupled with the economic ability of the teams to pay for more tests and more exams. Youth and high school athletes generally get less of a PPE, and you kind of look at risk versus benefit in that case. And so as long as when you are conducting PPEs, you are doing what is considered the standard for that level of play. The NBA has a certain standard. Middle school basketball would be held to a different standard. So as long as you're providing a PPE that is in line with what would be reasonably expected, you should be covered. Pre-participation liability. Here versus US found that a physician may be liable for not using recognized appropriate tests or consultation when necessary. And so may be necessary to consult with specialists, and the team physician may be found negligent for failing to consult. We go back to the case of the Marfan's aneurysm, but also we've all had cases where there may have been some complexity, whether it's a neurologic issue, an orthopedic issue, cardiac issue, and it's always helpful to make sure that you consult with specialists, especially on those cases that are confusing, not straightforward, or complicated. So one of the main responsibilities of being a team physician is clearing an athlete to have them return to play. Generally the team physician has that primary responsibility, and that should be done within the bounds of acceptable or reasonable practice. A lot of this comes back to national guidelines, and AMSSM has been done a great job of making sure that our position statements, consensus statements are kind of re-looked at every so often. But those documents are very important to be up to date on those as you're making kind of return to play decisions. I know there was just a new mononucleosis position statement that was put out by AMSSM. There was a bloodborne pathogens one put out recently. So being abreast of what the latest position statements are, consensus statements, national guidelines, is really kind of what's needed when returning athletes back to play. And the team physician should refuse clearance if they believe that the athlete is at significant risk or harm from participation. And so a lot of us think this way, and a lot of us do this, but there are some cases where there have been some lawsuits against physicians or institutions that had barred the right to play. And we'll talk about, who has the final say, who has that legal protection in a little bit. One of the things that is tricky when it comes to clearance to play is athletes with disabilities. No constitutionally protected right to play, but both the Americans with Disabilities Act and the Rehabilitation Act prohibit discrimination against people who have physical abnormalities or impairments. The team physician may require an athlete to have a reasonable physical qualification. For example, if someone is blind and they want to do downhill skiing, that may be a challenge if they don't have the appropriate things in place. And so if those accommodations aren't able to be provided, then maybe that particular athlete should not be cleared in that situation. But it is illegal to exclude an otherwise qualified athlete without substantial justification. And otherwise qualified means that they could satisfy all the requirements despite impairment. And so you might think of, maybe somebody who either had an amputation of an arm, or maybe they were congenitally born with only one functional arm. Because they have a disability, that doesn't mean that they can't play certain sports. Even throwing sports, I go back to thinking about Jim Abbott, who pitched for the University of Michigan and then for the California Angels. He only had one functional arm, but was able to use that glove hand, throwing hand, and he had a really unique way to move that glove over to his shortened arm and then back to his other hand, and actually had a lengthy career. So he would be otherwise qualified because he could satisfy all the requirements of playing baseball despite his impairment. So when you're making those clearance decisions, the key is really on risk to the athlete. Are they going to do harm to themselves or somebody else? And really, if they have some sort of disability, make sure that you've thought through, can there be reasonable accommodations for this athlete? And would I be liable if I disqualified them without thinking through that? So a couple cases that really are key cases and ones to know. Puhulu versus the University of Kansas. The federal court initially upheld the team physician's conservative medical disqualification of a football player with narrow cervical canal. The team neurosurgeon or the neurosurgical consultant felt like the athlete was at extreme risk. So what do athletes do in this sort of case? They go out for a second, a third, or a fourth opinion. In this case, the athlete went to 3 other neurosurgeons who claimed that the athlete was at no increased risk. And so Puhulu brought that back to the University of Kansas and said, look, I've got 3 other neurosurgeons who say I should be able to play. Therefore, I want to play. You disqualified me, so now I'm going to file a lawsuit. The athlete was willing to sign a waiver. But ultimately, in the end, the court withheld the team physician's disqualification, saying that the team physician ultimately has the right to make the right decision for the team, the athlete, and the institution. Another similar case is Knapp versus Northwestern. This is a little bit more recent. Knapp was a basketball player, suffered cardiac arrest and ventricular fibrillation, CPR, defibrillation, and then had an AICD implanted. The trial court held that Northwestern's exclusion of the player violated the Rehabilitation Act of 1973. And while the determinations of risk were admittedly made without a reasonable degree of medical certainty, at that time there was really little evidence regarding can athletes play with an AICD. Risk to Knapp would not be substantial after 2 years. And so that ultimately went to the appellate court. And again, the right of the team physician and the institution to make that disqualification was upheld. So again, the team physician has that right to represent the university, as well as protect what they believe are the interests of the patient. Lastly, a recent case from 2015, Class versus Towson University. He was a lineman, had a heat stroke, had a sudden cardiac arrest, liver failure, ultimately had 14 surgeries, and had a long stay in the hospital. Cleared to play by the doctors at the Shock Trauma Center, and had several experts in heat stroke and heat injury come in and say, he's recovered, no further risk. Towson and the physician there did not clear that player to return to play because they felt that the risk of playing is too great. Class initially sued Towson and won in district court, but again, that case was overturned by the Fourth Circuit Court of Appeals, again, holding that the right of the team physician to make those decisions, is the right one. And so again, team physicians have a right to make the decision both for themselves and the university on whether an athlete can be cleared to play. And the courts have held that in 3 major cases. And so that's an important concept. So again, if we think about participation, we talked about Knapp versus Northwestern, the legal right of the school and the team physician to disqualify competitive athletes with cardiovascular abnormalities, ultimately for protecting the health and welfare of young sports participations. And in Class versus Towson, the appellate court sets the right of the school to set return to play eligibility criteria. Team physician judgment and derivatively Towson University judgment were not unreasonable in the context. And so further evidence that the courts have held that universities and physicians can make those decisions. Liability waivers, we looked at in the Puhulu versus Kansas case where he's like, I'm willing to sign a waiver. They may agree or elect to sign waivers and say that we won't, hold the defendant or the university or the institution liable. But those don't always hold up, and some court uphold those, but not all. And so some conduct, if it's intentional, if it's reckless, or it's grossly negligent, you could still be found liable despite the athlete signing a waiver. And so the courts have held that those waivers are not always protective for the university, even if the athlete willingly agrees to sign one. A lot of confusion comes into the Good Samaritan case. I know many of us early in our careers, many of us still, volunteer to cover high school football games or, stand out on the sidelines in a volunteer status. So a physician who voluntarily provides medical services for a sports program at an institution of higher learning, such as a public or private school, is not liable for any damage which may result from provision of services. Okay, but the shield of immunity will be lifted if the physician receives compensation for the services, or if the physician's performance constitutes willful or wanton misconduct, gross negligence, or intentionally tortuous conduct. And so even if you're volunteering and you're providing care, if it's negligent or grossly goes against the current standards, you may still be held liable. There's a few more nuances to the Good Samaritan law. If you are the de facto team physician and you have a relationship with the athlete or the team outside of that particular game, even if you're not getting paid, there has been found to exist a duty to care or a responsibility or an assumption of care. And sometimes the Good Samaritan law does not apply there. Certainly, if you're receiving a stipend or any sort of monetary compensation to provide sideline coverage, you're no longer covered by the Good Samaritan Act. And in some cases, the Good Samaritan provision only covers emergency care. And so it's really important to check your local standard, make sure that you know what is your state's law to make sure that you're not putting yourself at risk when you're volunteering. Immunity. And so a lot of times certain things may be immune. So team physicians employed by public universities may be protected by state law. So that's not to say that an athlete couldn't file a lawsuit, but rather than filing the suit against the individual physician, that suit would likely have to go against the public university. State workers' comp laws may bar claims of professional athletes against team physicians, except for in cases where there's been fraudulent concealment or existence of a previous injury. And so again, that is state by state, and sometimes you've got to make sure that you check that. If a consulting physician is an independent contractor rather than a team employee, may be liable to for a tort suit. So myself, for example, I am a MedStar employee, but I provide care for the Washington Mystics, and so I am not a team employee. So that means I may be liable in a tort suit. They would likely include MedStar in a suit because MedStar is worth a few more dollars than I am. All right, so this was one of the things that Chad Carlson started back in 2012, and we worked on it through practice and policy. I was fortunate enough to be able to go testify to Congress for this. But the Sports Medicine Licensure Clarity Act really was a valuable act in protecting, team physicians that travel with teams from state to state. Certainly in the non-team physician, non-sports medicine status, it's against the law to provide medical care in a state in which you don't have a license. But it would be impractical and nearly impossible for a team physician to then have to look at the schedule ahead of time and say, well, I need to get a license in all of these different states because I'm traveling with the team to play there. There are some key components to this law to be aware of. So the bill extends liability insurance coverage of the state licensed medical professional to another state when the professional provides medical services to an athlete, athletic team, or team staff member pursuant to a written agreement. So it's helpful to kind of think if you started, say, in the state of Maryland in a bubble, and your team was traveling to Virginia to play, as long as you are within that bubble of taking care of your team only, and doing it in a non-healthcare facility, that is covered by the Sports Medicine Licensure Clarity Act. This extension does not apply if you go into a healthcare facility. So if you travel from Maryland to Virginia and you bring your athlete into the emergency room, now you kind of have to take hands off and allow the doctors with the Virginia license to provide that care. Also, it would be very hard to go into a facility that you don't normally work at, don't have credentials to provide care as well. So once you get into a healthcare facility, the Sports Medicine Licensure Clarity Act does not hold. Also, if you're transporting the individual to a healthcare facility, if you're in the back of an ambulance and you travel from Maryland to Virginia, you're no longer covered there. But as long as you're staying in your bubble with your team and providing care that's outside of a healthcare facility, you should be shielded by the Sports Medicine Licensure Clarity Act. Now we're kind of getting towards the end, and this is the future, and who knows what will really become of this with what's going on. Many of you are aware that there are several, NCAA lawsuits that have been settled or have been, won or determined. House versus NCAA was really a big one on NIL and revenue sharing, and there was just a proposed settlement that was agreed to by the judge. But once athletes are now part of this revenue sharing and with these NIL deals, now there may be agents involved in college athletics. Now that athletes are able to make money from their ability to play college sports, if you hold them out of a game and now they miss, a game or two or three, and that impacts their revenue, that may lead to a lawsuit. And this even goes back to many states are now passing the ability for high school athletes to be able to get name, image, or likeness deals. And so this will be something to watch for. Will high school and college athletes look more like professional athletes? Will they have agents? Will there be more liability? And so time will tell on this. When you think about other NCAA lawsuits, Johnson v. NCAA, found that athletes may be considered employees under the Fair Labor Standards Act. And that really looks at that 20-hour-a-week student employee, but still an employee. And then the Dartmouth basketball team and the National Labor Relations Board, where they unionized their basketball team. Well, now if they are employees, are they covered under workers' comp? How is that going to work? Does that give them more liability if you're now again restricting their ability to earn money? And so those are cases really that we kind of have to watch and see what happens. Continuing medical education, believe it or not, there is a legal standard that says physicians have a legal obligation to keep abreast of new developments and advances in sports medicine, and they may be liable for using outdated treatments that no longer have a sound basis. And so big plug for continuing medical education. AMSSM has continued to lead the way on physician, sports medicine physician, CME. Here's the early release brochure for the 2025 meeting that will be in Kansas City, April 22nd to 27th. But that CME is really something that legally you need to keep up with the latest in sports medicine. And if you're not following the latest standards, that may open you up for legal liability. So to kind of summarize kind of the key points that we talked about is physicians must practice according to the accepted standard, and therefore you need to be, up to date or current with what the accepted standards are. Must consult when necessary. And so if you have a complicated case, or, you're not a neurosurgeon, in order to protect yourself, it's very helpful to bring a neurosurgeon in on board to make or help you make that decision, on those complicated cases. As we learned, universities and team physicians have the ultimate authority to clear or not to clear athletes, and the courts have found in several cases that that's the case. Good Samaritan protection is lost if there's money involved or if a duty to care exists, so in a pre-existing relationship. So if you're a physician that provides, say, a training room at the high school on your way home from work one day a week, and then you show up at the game, well, now you've been recognized as the team physician, and there's a duty that you are an expectation that you'll provide care at that game. And so that may void your Good Samaritan protection, depending on what state you live in. There is an obligation to keep current and up to the current practice and standard of care, so CME is important. And really the last thing is it's uncertain the future of college or high school athletics and what that may mean for legal liability or the impact on sports medicine. So that's all I had. We do have 2 CAQ questions kind of geared up or loaded up for you. Myro, I don't know if this is the point for that.
Yeah, let's go ahead and do the CAQ questions, and then we'll go ahead and get any other questions from the group. If you want to go ahead and submit it in the chat now, I'll ask them after the questions. There you go. So, as a sports medicine specialist, you are asked to volunteer to cover the medical tent for a midsummer ultra triathlon. You are very excited to cover this event as it is a personal interest of yours, considering that you are not receiving any financial compensation for covering this event. You make several assumptions regarding the care you will provide during this event. Which of the following assumptions is true? Okay, so the correct answer in here was B, because you're covering the event within your area of expertise. You are better able to reduce the risk of allegations of gross negligence. As we talked about earlier, the Good Samaritan laws are not designed to provide protection for volunteer athletic events because the legislation generally does not apply to non-emergent care. The volunteer event physician who provides non-emergent treatment such as laceration repair, sprains and strains, or simple fractures, is often not protected by the legislation. General event liability insurance is usually available, and event organizers commonly buy this coverage. However, these general liability insurance policies do not provide coverage against medical liability. The physician must consider utilizing their own professional liability coverage or purchasing a separate specific medical liability insurance for an event, keeping in mind that these policies are usually cost prohibitive. And then you must check with your policy provider to ensure that you are covered under your personal or institutional coverage. Never assume coverage. Courts will generally not validate a contract with a release, which releases a physician from liability in caring for a patient. Medical services are considered an essential public service, and courts have found these waivers in violation of public policy. Physicians may be able to reduce the risk of allegations of gross negligence by practicing within their scope of expertise. And for example, a sports medicine, family medicine, or orthopedic provider will be better protected against allegations of gross negligence than will providers in other unrelated specialties such as psychiatrists or obstetricians. Okay. And so we'll go to the next question here, and I'll go ahead and read before Andy puts up the poll. And you are the designated team physician for a local high school. Your athletic trainer calls you and tells you that a soccer player who has been out this season due to a tibial fracture saw his orthopedic physician today and was cleared to begin playing this afternoon. You have never evaluated the player for this injury. What is your most appropriate action? I think overall, you can see my comments here. Again, the team physician should establish a safe return to practice to competition process for an injured athlete. The team physician for a high school may not be the sole provider for the student athlete. Oftentimes, there may be other providers involved in the treatment. Chain of command regarding decisions to return an injured or ill athlete to practice or competition should be established, ideally in the off-season in coordination with the athletic trainers and the coaching staff. The return to play decision should not be rushed as it can be a complex process involving the health status of the individual. Athlete's health status should be evaluated and potential risk of return to play should be taken into consideration and discussed with the athlete and parents or guardians if the athlete is a minor. Although evaluation by an outside provider should be considered, return to play is a decision that should be made by the team physician in coordination with the athletic trainer. So the overall answer, just like everybody got there, it's you are the team physician, the head team physician. So again, you're the one who should be making the decision. And as Dr. Asplund said, um, uh, you are you are the go-to, and as far as the person who's responsible for caring for the athlete, who is your primary focus. And so overall, that is all I have for the questions, and I'll stop sharing my screen. I'm going to go ahead and check the chat here to see if there's any additional questions. We have one here that says, with the recent changes allowing college athletes to receive professional scholarships, how do you anticipate this will affect the responsibilities and liability of the team physician?
Yeah, that's a great question, Ann. It's great to see you on. Thanks for the question. I certainly think that as there's more financial impact involved, that's going to increase the liability of the team physician. The American Orthopedic Society for Sports Medicine, in maybe two issues ago of Sports Health, put out a pretty concise statement around how the risk of the liability risk is increasing in professional sports as they're starting to sign these $50 million contracts and things like this. But I can see, we now have college athletes with $3 or $4 million NIL deals. And like I said in the lecture, lots of high schools are now allowing this as well. And so I do think that as there becomes more money involved, did I get bumped out, Myro?
Okay, so you're back on, Chad, and I can see we can hear you. So if you were able to finish your thought, I know it was one of those that you just got cut off.
Okay, so I mean, I think that to short answer to the question is yes, I think liability risk is going to increase. Um, and I think that there's probably going to be more lawsuits now that there's more financial involvement. So, but time will tell, and we'll see what kind of guardrails are put up. I think ultimately collective bargaining is going to need to happen. And I think that, hopefully in the next couple of years, we have a little bit more clarity.
Thank you, Chad. I guess there's no other questions. I have one additional question. I know you talked about the Sports Medicine Licensure Clarity Act, and I know you talked more of like and you talked also about like crossing state lines. I don't know with the Olympics and international countries, does that also apply, or is there a similar policy that covers sports physicians who travel internationally?
Medications you can bring into the country, and it's good to make sure that you know that ahead of time, or what you can travel with. A lot of times, unless you have specific licensure or permission it may be illegal to carry narcotics or controlled substances out of the country into another location.
And Chad, I know you were frozen just in the very beginning. We got the part on narcotics. Was there any other considerations for covering internationally?
Um, no, again, as long as I mean, so as you say, you go to the Olympics, each team will have a medical treatment area. Each medical staff is supposed to be credentialed by the organization. And so as long as you're providing care to your athletes within your designated medical area, you should be covered there.
And then, Chad, there was one other question. Would we be covered if spectators were injured? So I guess if they stopped an event or if you had to go up into the stands to help out a spectator.
So that is one of these areas where that would depend, state to state. Typically, if you are providing care while awaiting EMS, if you're providing emergent care, say someone in the stands has a heart attack and you are providing CPR, getting the AED, because there's not an expected responsibility to care between a team physician and a spectator, you may still be covered by the Good Samaritan Act there, as long as you're, providing care until EMS arrives on scene or until the patient can be transported. Now, if it is a minor injury to a spectator, and it's not emergent care, you may not be covered, and it all depends on kind of what is the setup. For example, in a lot of the professional arenas, we provide care to the athletes and a lot of times the team staff, but there's a medical group in the stands that is responsible for taking care of participants for their regular medical needs. And so I would say you'd be covered if it was emergent care for a spectator while awaiting, definitive care. If there was not an existing relationship. And so, but it may depend state to state.
All right. Thank you, Dr. Asplund. So I guess that is the last question. Again, thank you everybody for joining in tonight for tonight's lecture. Make sure to tune in next week as well. And Dr. Asplund, thank you very much for coming on tonight and giving us a talk.
Thanks for having me. It was fun. I look forward to doing one of these again soon.